Good afternoon, everyone. The beautiful day. We will hear the cases in the order in which they are on the docket. For the appellants, please remember you can reserve some time for rebuttal if you wish. And if there are no announcements or other matters to take up, would you please call the first case?
Michael Dinovo Jr. et al. Versus Kenneth Binkley et al.
Good afternoon, Your Honors. May it please the Court. I'm Thomas Smith, and I represent the appellant in this case, Michael Dinovo Jr., along with Mr. Tony Seaton and Mr. Andy Davis. Your Honors, I'd like to request to reserve 3 minutes for rebuttal.
3 minutes, all right.
And during this argument, I'll probably be referring to Southern Energy Company as Southern, just to keep it short. So if I do that, it's just shorthand. Your Honors, this is a case of fraud, specifically intentional misrepresentation by Southern against Mr. Dinovo, who was performing work as an independent contractor when he was critically injured. There's no dispute about that. In the appellant's brief, they agree that when he was working for them, he was an independent contractor.
I thought there was some question about that perhaps he was an employee and he filed income taxes as an employee and he went through workers' comp as an employee.
So, Your Honors, the evidence to that is that only by Mr. King, the president of Southern, claims that he had a conversation with Mr. Dinovo 2 weeks before the incident. Mr. Dinovo denies that this conversation ever happened. Now,
but as the judge said, didn't he receive workers' comp benefits and sign a pleading indicating that he was an employee at the time?
He did, Your Honor, and the reason for that is because of Southern's actions. Once this fire and this incident happened where Mr. Dinovo was critically injured, while he's in a medically induced coma, Southern, through their insurance company, Federated Insurance, calls his wife and says he's an employee. He's been converted to an employee. And they say it happened a couple weeks before the incident, even though there's no proof of that. They increased overnight his pay from $20 an hour to $30 an hour. They said that his mountain of medical bills, which has now been $700,000, is going to be paid through workers' comp. And he's going to get a workers' comp settlement of $300,000. Now, when Mr. Dinovo came out of his coma, he firmly believed, as he always did, that he was an independent contractor. It never changed to him. However, he had no proof that Southern didn't just go behind his back and convert him to an employee. So he hires an attorney, Mr. North, to investigate. And Mr. North is told by Southern's vice president, and by Federated Insurance, that he was converted to an employee 2 weeks before the incident. However, any documents proving that were destroyed.
Counsel, in asserting that he's an independent contractor rather than employee, it seems like a lot of what you're relying on is information that he would have had. His authority to hire somebody who's subordinate to him, the manner in which he was paid. How exactly does a fraud claim work here? And just reading through the analysis in your brief, it struck me that most of that is in no way contingent upon what Southern told him. It's instead information that he already possessed or had of his own knowledge.
Well, his information was what he did on an annual basis, which was work as an independent contractor. Of the 7-factor test that used to be done and would apply in this case, 5 of those factors go in favor of him as an independent contractor. He controlled the method of his work. Everybody agrees that he was an independent contractor. However, he had no information about whether Southern changed his status to an employee, and so without that knowledge,
wasn't he aware that there was actually no conversation 2 weeks ahead of time? And he has that knowledge, that information, that this conversation that Southern's saying happened didn't actually occur.
We didn't know about that conversation, Your Honor, until 2018. That was the issue here, is that's the first time that Mr. King or Southern actually stated where they got that information from, that the conversion happened. And it was in the deposition of Mr. King before the suit was amended to become a party, where he admitted that he had a conversation that he was going to make Mr. Dinovo an employee, nothing else. That's where that conversation comes from. And that's the first time Mr. Dinovo would have ever become aware of it. And so that's where this situation comes from, is he had no ability to challenge Southern's assertions against him that they had made him an employee. And now we know through deposition they never did. That conversation was a lie. There's no documents to prove he was ever an employee. And
Counsel, would you agree that fraud has to be pled with particularity?
it does, Your Honor.
What would you
this-
point the court toward to show that you adequately pled fraud in this case?
It's in the amended complaint in March of 2019, where the amended complaint says that there's a claim of intentional misrepresentation against Gary King, and through vicarious liability, respondeat superior liability, the Southern would be liable for the actions of their agent, Gary King. And
Is there any greater detail that's afforded in terms of the misrepresentation that occurred? And I don't want to get too particular, but with particularity. But what paragraphs would you reference as? What part of the amended complaint would you suggest that we should pay particular attention to?
Yes, Your Honors, and that is, let's see here, paragraph 50 of the amended complaint, intentional misrepresentation, where they lay out in detail what Gary King did. And so that would be paragraph 50 of the amended complaint, which survived the motion to dismiss by the trial court. Your Honors, in this case, fraud, as this court has held, the Supreme Court has held, can ordinarily not be dismissed on summary judgment. It's not appropriate. And in this case, we have a valid claim of intentional misrepresentation. Going through the elements, to recover for intentional misrepresentation, the plaintiff meets all 6 elements here. And I'll go through them. One, that the defendant made a representation of a present or past fact. 2, that the representation was false when it was made. 3, that the representation involved a material fact. 4, that the defendant either knew that the representation was false or did not believe it was true, or it was made recklessly without knowing whether it was true or false. 5, that the plaintiff did not know that the representation was false when it was made and that he justifiably relied on it. And 6, that the plaintiff suffered damages here. Now, going through this case, every single element is met. First, the representation made by Southern was a past fact, that Mr. Dinovo had been converted from an independent contractor to an employee. Second, based on the evidence discovered from the depositions of Gary King and Burt Landers, Southern's assurances to Mr. Dinovo and giving him a W-2, so actual evidence of employment. See, that's the thing, it's not just verbal assurances. It's a W-2, which is only given to employees. Independent contractors get 1099 forms. And it's within their control. Southern controlled their own payroll. They determined what documents to give, and they gave him a W-2, which they could manually manipulate. So second, based on the evidence discovered from the depositions of Gary King and Burt Landers, Southern's assurances that Mr. Dinovo was converted to an employee was false. Third, Southern's representation concerned a material fact, because if Mr. Dinovo is not an employee, he can't get workers' compensation benefits. He has to be an employee to get those, or he's ineligible. Fourth, Southern knew that this conversion was false when it was made. Mr. King was asked whether he informed Mr. Dinovo in his first deposition that he was being converted to an employee, and all he could say was, "I'm sure I did." It was in the second deposition, after he became a party, that he then changed his testimony about how this happened, said, "I had a conversation with him a few weeks before this happened, told him he was going to be converted to an employee." That conversation never happened. At the very least, it's a highly disputed issue of material fact. Fifth, Mr. Dinovo did not know that the conversion was false, and he was justified in relying on Southern's assurances. They told him he was converted to employee. He was given a W-2. He had no evidence, physical or otherwise, to contradict that. So he's relying on them, as well as Mr. North, through what he was told, had to rely on it because they had no evidence to the contrary. And it was only years later, in 2018, when these depositions occurred, that it was discovered. And particularly with the accountant's deposition, we realized, see, Southern used two types of paychecks for employees, vendor checks for independent contractors. Mr. Dinovo, the entire time he was employed, was paid with vendor checks, and that continued after the fire. He was always paid with vendor checks. They never took out any taxes. They never gave him benefits. They never paid overtime. Even after they say he was converted to an employee, they never paid him as such. And that's where we understood at that point, that is evidence right there that he was always an independent contractor. His role never changed. Nothing about his status changed, and his pay never changed.
How did they send him a W-2? They didn't take any withholding?
They did not.
They just paid him as an independent contractor even on his W-2?
Correct. The W-2, I believe, might show some withholdings. His vendor checks show no withholdings whatsoever.
I know, but I'm interested in the W-2.
Yes, sir. I believe, and I'd have to look at it again. I believe it does show some withholdings, but the checks he actually received showed no deductions whatsoever. And as we said, because Southern controlled their books, they controlled their payroll. They can do whatever they want with it.
So you're saying that that even after the injury, he was paid with these vendor checks that he'd been paid with previously?
Correct, Your Honor.
They showed no withholding, but yet he got a W-2 that did show withholding?
Correct. So Mr. Dinovo was reasonable in justifying relying on Southern's assurances that he was converted. He had no other choice. The exclusive remedy for employees is workers' compensation. And with facing mountains of medical bills and never working again, he got burns to 50% of his body. He'll never work again. And facing all that stress and no way else out, he chose to go through workers' comp. And it was only through these depositions when it became clear he was always an independent contractor and that this fraud had happened to him, that it became clear that Southern was liable for this. They had intentionally misrepresented what had happened to him. But the sixth factor, Your Honors, is that Mr. Dinovo has suffered damages because of this fraud. In relying on these fraudulent assertions, his medical bills were paid and he got a settlement of $300,000. The amended complaint seeks $25 million. He gets total loss of earning capacity, punitive damages. TOSHA found 20 violations. So he has a lot of damages here. I've run out of time, Your Honor. I'll answer any other questions you all have.
Thank you.
Thank you.
You still have your rebuttal time.
Your Honor, always a pleasure to be here. My name is Lance Thompson. I'm here for Southern and Mr. King, along with Clint Woodfin. So Mr. Dinovo, already receiving over $1 million workers' compensation benefits, is now seeking double recovery in this case. The appellant states that this case is about fraud. However, Mr. Dinovo has not established any of the elements for fraud, has not established any proof for fraud, except for what you've heard today, oral arguments. The trial court properly determined that there was no genuine issue of material fact as to Mr. Dinovo's employment status. In light of the evidence presented to the trial court properly found that the doctrines of res judicata, collateral estoppel, judicial estoppel, all applied to prevent the appellant from seeking double recovery. As to the issue of exclusive remedy.
How do these estoppels apply? How does judicial estoppel apply, for instance?
So judicial
Does judicial estoppel require a sworn statement?
Judicial estoppel requires a sworn statement.
Where's the sworn statement?
The sworn statement, from what the trial court found, was the factual statements made to the Workers' Compensation Commission, or court, about his employment status. They took those factual statements, which were made by Mr. Dinovo and by legal counsel, and incorporated it into a judgment.
Where are these statements shown to be sworn?
The statements to be sworn, let me pull this.
Is there a record of that?
Well, what we're arguing and what the court did hold was that the statements made in the workers' compensation agreement that was submitted to the workers' comp court were statements of oath, sworn statements.
But they weren't sworn, were they?
The court found that they were.
Well, I'm asking you, is that in the record? Is a sworn statement in the record that was signed by him? I couldn't find it.
Well, Mr. Dinovo did sign that statement along with Southern. There was an agreement that was entered into, and the workers' compensation court signed.
Was it sworn to? Is my question.
I believe that was sworn to. And the reason I say that is the court was relying on factual statements made by Mr. Dinovo through a workers' compensation attorney. Attorneys have an obligation under Rule 3.3. They cannot present false statements to a court of law. So they are making truthful statements to a court.
Well, he may have thought they were true. I don't know. But judicial estoppel requires a sworn statement. And I'm just asking, do you have a sworn statement?
I believe that's the sworn statement, but if the court finds that judicial estoppel would not apply, the other three doctrines would apply. So there's at least 4 grounds for.
And how does collateral estoppel apply?
Collateral estoppel applies because, well, this is a doctrine that has 5 elements. Okay. So Mr. Dinovo's employment status is identical to that action. So, for example, the issue was presented to the workers' comp judge that either he was an employee or obviously not an independent contractor, otherwise he's not going to get workers' compensation benefits. The issue was raised to the court as a factual statement that Mr. Dinovo was acting within the course and scope of employment when his entry occurred.
Let me ask you this. Did the workers' compensation specialist, or whatever the term is, did he undertake an employer independent contractor analysis? Did he make that analysis?
He did not. And
well, then how can collateral estoppel apply?
Well, so first, the reason the workers' comp judge would not undertake that analysis is because you're already going to the court with that fact being determined that you're an employee. Otherwise, the appellant's rightful course would have been to just file a tort litigation from the beginning when they questioned whether or not he was independent contractor or workers' comp. What I've seen in case law and cited in our brief is the Gerber decision, which talks about a consent judgment to the effect that a workers' compensation agreement goes before the court based upon factual statements. These are issues that are actually raised and litigated before the court. And you can do that through a settlement agreement because these are issues that could be raised. And they could be raised in the sense of the appellant had a choice. Were they going to file a workers' compensation action or were they going to file a claim in tort?
So an alleged fraud on the part of Southern against Mr. Dinovo and the workers' comp court or workers' comp panel doesn't vitiate any of these estoppel arguments? Question mark.
Well, I'm trying to understand. I don't understand the question completely.
You were alleged, your company, your client was alleged to have committed fraud. Does that in any way vitiate or do away with the notions that collateral estoppel or res judicata could apply because your client allegedly lied to the fact finders?
If there were facts before the court that could establish fraud, which are not present here, that might be a different argument.
Well, if there weren't any facts presented as to fraud as to in the prior proceedings, right? But that's because of the fraud.
Well, that's because of what the appellant is alleging as fraud. You know, for example, the appellant was up here talking about contradictory statements of Mr. King, saying, I'm sure he was an employee, and then stating that he had a conversation with him. That's not fraud. That doesn't even come close.
It is if it's not true.
But there's no evidence to the contrary. And at the time when this workers' compensation settlement was presented to a court of law, Mr. Dinovo and his wife questioned their status. They engaged with a workers' compensation attorney to investigate this and determine what course of action they would take. You're not bound to file a workers' compensation action unless that's your only remedy in the law. But if you do have a question about that, which they did, they could have just filed this very same lawsuit. But they didn't do that.
Possibly because of fraud.
I realize that's what they're
This
arguing,
is sort
but
of
they
circular.
still.
I mean, you're arguing that they didn't allege anything, but they didn't allege anything back then because allegedly they were tricked. Isn't that right? Isn't that the way it works?
They're
They
claiming,
didn't make those claims because they were tricked into thinking he was an employee.
that's what they claim. But today they still come to court with no evidence of fraud. So they can say it all day long, but to have a case for it is a completely different issue.
Well, if he was continually being treated as an independent contractor until after this incident happened, and all of a sudden he's now being treated as an employee, allegedly. And apparently even being, I'm not sure I'm not even sure about this story with the W-2 and whether or not there was actual withholding or not, but according to counsel, he was still being paid with vendor checks even after the incident occurred, even though y'all were saying he was an employee.
Well, Mr. Dinovo, I believe, did receive a vendor check after the incident, but he never worked another day again. So he wasn't actually being paid afterwards. He just received his check.
Well, he was being paid for the time he worked. I assume that last check was probably for the time he worked. Is that right? He would have gotten a check for the time he worked, including the date of the injury.
He would receive a
was that
check.
paid with a vendor check?
I'm not sure about the issue of the vendor check because I have not seen that in the record, and I'm not really sure how to respond to that without it being there.
So you're saying the vendor checks are not in the record? Was this an argument that was raised below?
I do not believe so. I do not recall seeing personally myself in the record as an exhibit to any of the pleadings that were filed.
Did you discuss it in front of the court below?
I did not discuss it in front of the court. I believe it might be raised in the appellant's brief.
Yes, but I'm asking about the court below.
I do not recall talking about the vendor checks. I think we probably were focused on the estoppel doctrines of
Okay.
res judicata, and one thing I do want to get into about what the appellants are trying to turn this into is a case about fraud when they didn't plead it, not against Southern. This is an unpled claim. There's actually all additional arguments that are even raised in this brief, such as statutory cause for rescission. For the first time on appeal, they've raised the issue of vicarious liability against Southern, claiming, well, they pled a cause of action against Mr. King, so therefore they pled a cause of action against Southern, even though the action was time barred.
So, in other words, is it your client's position that this has never been pled in the trial court?
Well, it's never been properly pled, yes, in the complaint. Now, was it an issue that was raised in the Rule 59 motion after summary judgment? Yes. They tried to create this issue before the court, essentially saying Rule 59 allowed them to reset the focus, even though that's not a factor under Rule 59.
He said counsel said intentional misrepresentation was pled in the amended complaint. Is that?
It's pled against Mr. King individually, but not Southern.
Not against Southern.
Right.
I see.
So I've got about a little less than 4 minutes.
I wanted to ask you, I know Mr. King was dismissed because of the statute of limitations, I think. Can you speak to the statute of limitations?
Yes, Your Honor. So Mr. King was brought into this lawsuit, I believe, around 2019. He was not pled as a person with fault from an original defendant in the amended complaint, so therefore it's outside the statute of limitations. So even though there was 2 other defendants, I believe, that alleged fraud against Southern, they did not do that against Mr. King, so they didn't preserve the statute. And with the causes of actions that they've pled, they were all just time barred.
Well, so I thought you said that this intentional misrepresentation was brought against Mr. King,
It was.
but that he was then let out because of the statute of limitations?
Statute of limitations, discovery rule would not have applied because at the time there was evidence that Mr. Dinovo questioned his employment status back to December of 2013.
There wasn't a statute of limitations issue as to Southern?
No, Your Honor. I believe that was because the original defendants in that case pled comparative fault against Southern, so that would allow it to continue.
I see.
All right. So in sum, trial court properly found that the exclusive remedy applied here after all the affirmations that were made, and as Your Honors had mentioned, knowledge within Mr. Dinovo's possession, repeated statements, engaged in a workers' compensation attorney to look into this. The undisputed facts established that he is an employee. The one doctrine I did not talk about was equitable estoppel, but those elements are also met because Mr. Dinovo affirmed his status. Southern relied on those statements and paid over a 7-figure settlement to Mr. Dinovo in reliance on that, and now the plaintiff is seeking double recovery. That's all I have.
Well, I think that's all we have to.
All right, thank you.
Thank you.
Your Honors, just to clear something up real quick, the statute of limitations doesn't bar this claim. When it was found out after the depositions of Mr. King and Mr. Landers, that opened up the discovery rule to a fraud claim against not only Mr. King because he's the president and agent of Southern, but Southern itself. And that was clear by the Supreme Court's decision in 2010, the Absher versus Methodist Healthcare Memphis Hospitals case, where they said you don't have to sue the principal or the agent. You can sue one or the other. So you don't have to sue the agent for the principal to become liable for the actions of their agent. And so when they say that the claim is barred, that is not true. The vehicle in which the claim was brought wasn't proper. It was comparative fault 20-1-119. However, the claim existed. At any time in those 2 or 3 years that a fraud claim can be brought, it was open. All plaintiffs needed to do was sue Gary King if they wanted him in. That doesn't mean the claim is barred. That just means it wasn't brought in the right way.
Counsel, why shouldn't they have known here sooner? You're saying that they got the vendor check, that they knew about the control issue. And there's a ton here indicating to the employee that the employee is an independent contractor. Now the employer is saying, hey, last minute I changed it before this accident occurred, and you're now an employee. Isn't there enough awareness there to essentially put the employee on inquiry that there's something amiss here that's going on?
Your Honor, that's a really good point. However, that doesn't mean that they needed to tell him what they were doing. When they say we converted you 2 weeks before the incident, how was he to know any different? They didn't have to tell him. And that's the issue, is he can only know what he's told. He could have done exactly what he did and still been made an employee. He couldn't contradict that by saying, one, he's got a high school education. He's not the smartest person in the world. He didn't go to law school, certainly. So he doesn't know exactly what an independent contractor versus an employee is. He doesn't know that analysis.
His attorney would have understood that distinction, though, and was investigating this matter.
Correct. However, again, attorneys are humans. We can only rely on documents and facts as we can get them. And when the attorney is told he's converted 2 weeks before the incident, there was nothing to contradict that, and he's given a W-2, which is physical evidence. So when you're confronted with physical evidence and verbal evidence saying you are converted to an employee, there was no way to get around that until the depositions of Mr. King and Mr. Landers were taken to actually get to the heart of the matter.
Are the vendor checks in the record?
They are.
Okay, so they will show he was paid in vendor checks right up to the end.
Correct. And Mr. Landers acknowledged that he was never changed.
And they acknowledged that vendor checks were for independent contractors.
Correct, Your Honor.
Okay.
Yes, sir.
Thank you.
Thank you.
Thanks to all of you. We appreciate it. So would you call the next case, please?